In the case Marbury v. Madison, midnight judges were nominated by President Adams last minute, and not all nominations were delivered in time for the next president, Thomas Jefferson, who told his Secretary of State Madison not to deliver them. Those men sued Madison, and judicial review was established where the Constitution is the highest law of the land, and judges can determine the constitutionality. In McCulloch v. Maryland, the second bank of the U.S. was chartered by Congress, and the state of Maryland tried to pass a tax legislation on the bank, where James McCulloch refused to pay it. In the end, Congress can create a national bank, but a state cannot tax a national institution. This case showed an increase in Congress and the federal government's power. In Obergefell v. Hodges, many states had bans on gay marriage and refused to recognize other states' licenses. This violated the Full Faith and Credit Clause, and the court ruled that the 14th Amendment guarantees certain liberties, including marriage. In U.S. v. Nixon, this is regarding the Watergate affair, and the court sought after audio tapes from the Oval Office where Nixon provided edited tapes and claimed he was immune to that subpoena due to executive privilege. Nixon was required to hand over the tapes because the court guaranteed that there was a limited executive privilege only in areas of military or diplomatic affairs. In U.S. v. Lopez, Alfonso Lopez carried a concealed weapon onto his Texas high school campus. He was charged under Texas law with firearm possession on school premises. The state charges were dismissed after federal agents charged Lopez for violating the Gun-Free School Zones Act, and he was convicted. The Gun-Free School Zone Act was deemed unconstitutional because it exceeded Congress's role for interstate commerce. In Barron v. Baltimore, Barron owned part of the harbor in Baltimore. City expansion accumulated debris in the harbor, so he sued the city for his financial losses because of the Fifth Amendment and eminent domain. However, the ruling stated that the freedoms guaranteed by the Bill of Rights are restrictions on just the federal government, not the state governments. In Gitlow v. New York, Gitlow was a socialist and was arrested for distributing a left-wing manifesto calling for strikes and action. Even though the Bill of Rights was a federal government-only thing, the 14th Amendment required states to honor freedoms of speech and press. But you cannot encourage violence, so he was arrested, and this began to apply the Bill of Rights to the states. In Dred Scott v. Sanford, Dred Scott was the slave of a traveling doctor, and they traveled throughout free states. Eventually, Dred Scott wanted to buy himself and his family out of slavery, so he sued. However, it was decided that no person descended from an American slave has ever been a citizen. This was overturned by the 13th and 14th Amendment. The 13th Amendment abolished slavery, and the 14th Amendment gave citizenship to all. In Plessy v. Ferguson, the state of Louisiana enacted a law that required separate railway cars for blacks and whites. Plessy, who is 1/8 black and 7/8 Caucasian, took a seat in the whites-only car. When he refused to move to the car reserved for blacks, he was arrested, and the separate but equal doctrine came into place, where if there were equal accommodations for blacks and whites, it does not violate the Equal Protection Clause of the 14th Amendment. Leading up to Brown v. Board of Education, African American minors had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. However, in this case, Linda Brown was walking forever to get to the bus to take her to an all-black school when there was a white school right next door. This overturned Plessy v. Ferguson and decided that separation is inherently unequal, and it violated the Equal Protection Clause of the 14th Amendment. After the original Brown v. Board of Education, the Supreme Court reconvened to find out a way to implement this new idea. In the University of California versus Bakke, Alan Bakke had applied twice to the University of California's med school. He was rejected both times. They were required to have 16 places set for minorities, and yeah, he was white. There was no single majority opinion, but they decided race cannot be the only factor, but it could be a factor for admissions. Korematsu versus United States was during World War II. Korematsu decided to stay even though it was against the executive order that gave the military authority to exclude citizens of Japanese ancestry from areas deemed critical to national defense. The Supreme Court ruled for the U.S. government, saying that times of national hardship and extreme times can allow some individual rights to be taken away. In Baker v. Carr, Baker and other Tennessee citizens noticed that a 1901 law designed to apportion the seats for the state's General Assembly was virtually ignored. This was bad because it ignored significant economic growth and population shifts within the state. Since legislative apportionment was a court issue, this expanded the Supreme Court's power. In Shaw v. Reno, after the first plan only having one black majority district was denied, North Carolina submitted a second plan creating 2 black majority districts. Eventually, the court ruled that the district shape was bizarre enough to suggest that it constituted an effort to separate voters into different districts based on race.